Hello, am I audible? Am I audible to all? If somebody can please reply on chat. Okay, I'll wait for a few to join. Actually, so this is our discussion session for prelims, and we'll be discussing our first test, sectional test that we conducted. We'll be taking the discussion for polity. It was from polity, and it was a half-length test. So I'll be discussing questions from that. Okay, so first and foremost, what should be the premise of this discussion? The premise should be that will not be trying to understand the concepts. Okay, the purpose of discussion is to focus on two parameters. One, where did you go wrong while you were attempting, and the second parameter is how to solve a question in exam. ठीक है, these are our two parameters of discussion. So our purpose is to identify कि कैसे आप improve कर सकते हो अपना application of knowledge, and essentially ये कोई knowledge building exercise नहीं है, but application improving और identification of weak and strength areas is the purpose of the discussion of tests. ठीक है. नाउ सी पिछले साल और उससे पहले जो क्वेश्चन के पैटर्न यूपीएससी ने चेंज किए हैं, वन थिंग इज वेरी एविडेंट, and that thing is that UPSC wants student to have high focus, ठीक है, because in the time of social media the attention span is reducing, so the purpose is to ensure that a student have a high attention span, ठीक है. And why do I say so? Because if you see, the questions are such that they are lengthy, ठीक है. दे आर आस्किंग सिंपल फैक्ट्स, इट्स नॉट दैट कि कुछ आउट ऑफ द ब्लू पूछ लिया जो नहीं आता है. दे आर आस्किंग सिंपल क्वेश्चन, सिंपल फैक्ट्स, बट दे आर ट्विस्टिंग द फैक्ट्स इन द सेंस उसको इस तरीके से रिप्रेजेंट कर रहे हैं कि उस स्टेटमेंट को पढ़ के समझना और सही आंसर मार्क करने में टाइम लगेगा, ठीक है. सो हमारा पर्पस क्या होना चाहिए थ्रू दिस टेस्ट? आर पर्पस शुड बी दैट फर्स्ट ऑफ ऑल कि हमारे जो क्वेश्चंस हैं वो अलाइन हो विद रिस्पेक्ट टू द डिमांड ऑफ यूपीएससी, विच इज़ व्हाट वी आर ट्राइंग टू डू. दिस इज आर पार्ट ऑफ रोल कि हमें क्वेश्चंस को अलाइन करना है. व्हाट इज योर पार्ट? दैट यू हैव टू ट्रेन योर brain in such a manner that you are able to solve one question in 1 minute, because that is the time that you have 120 minutes and you have to solve 100 questions. So you just have 1 minute per question, so your focus, your attention and your processing should be that fast, ठीक है, that at least you read and solve questions, ठीक है, and over a period of time it will develop. Okay, so that is the purpose. Okay, so with that, let's begin our discussion for today. ठीक है. और अगर हम फर्स्ट टेस्ट की बात करें तो इट वाज अ हाफ लेंथ टेस्ट, इट हैड 50 क्वेश्चंस, ठीक है, एंड इट द मार्क्स वर 100, एंड द सिलेबस वाज दिस: हिस्टोरिकल बैकग्राउंड, making of constitution, salient features, preamble, union territory, citizenship, fundamental rights, DPSPs, fundamental duties, amendment to constitution, basic structure, parliamentary system, federal system, and center-state relationship. Okay. So question are thus, and what kind of bifurcation we had given was there was 23 questions which were easy factual questions, and there were 17 medium difficulty level question and 10 difficult level questions. ठीक है. So this is how the questions are bifurcated, and this is how in which topic we have questions, number of questions, easy questions, medium, difficult per topic. So let's start with the very first topic, which is your historical background. So what I have done in order to be easy for you, I have taken questions topic wise and I have labeled them as easy, medium or difficult. देखो इससे आपको क्या बेनिफिट होगा, द बेनिफिट यू विल हैव दैट यू विल नो कि आपने इजी क्वेश्चन गलत किया है. दैट मीन्स आपको वो क्वेश्चन तो सही करना है, बिकॉज इजी क्वेश्चन का मतलब क्या है, दैट इट इज़ अ सिंपल फैक्चुअल क्वेश्चन. मतलब जो बच्चे ने बुक पढ़ी है, जो बच्चे ने रिविजन की है, जो बच्चे ने रटा है बैठ के, उसको आता होगा. ठीक है. एंड वो क्वेश्चन तो आपको आना चाहिए. यू कैन नॉट गो फॉल्टी ऑन इजी क्वेश्चन. ठीक है. एंड इट विल ऑल्सो टेल यू कि आपकी एप्लीकेशन डिफिकल्ट और मीडियम में कैसी है, बिकॉज दे आर एप्लीकेशन बेस्ड क्वेश्चन, दे आर नॉट सिंपली फैक्चुअल क्वेश्चन, दे आर ट्विस्टेड क्वेश्चन, दे आर लेंदी क्वेश्चन. ठीक है. So this is the purpose of easy, medium and difficult bifurcation. So we'll start with the very first question, which is on from the historical background. Consider the following statement regarding the constitutional and administrative developments in British India post 1857. So while the very first statement is, while the Government of India Act 1858 ended the dual system of governance, it did not initiate the process of associating Indians with law making process. Now this statement is correct. Okay. The The Indian Council Act of 1861 marked the beginning of legislative decentralization by restoring law-making process to Bombay and Madras presidencies. ठीक है. Third is the power to discuss budget and introduction of separate electorate for Muslims were both introduced simultaneously under Indian Council Act of 1909. Now the interesting part is, अगर आप note करो, that इसने बोला है power to discuss budget and introduction of separate electorates. Now although introduction to separate electorates for Muslim were given under 1909 Act, the power to discuss the budget was not was given prior to this. It was under Indian Council Act of 1892. ठीक है. That is why your option third is incorrect. And when you remove option 3, you are left with 1, 2 and 2. And we know 1 is correct, so answer is 1, 2. And for that matter, second statement is also correct. Okay. So this was one thing. Now, अब ये वाले जो आपके historical development वाले topic है ना, you cannot make sense out of it. तो there is no cheat code. इसको तो बैठ के रटना ही पड़ेगा. ऐसा नहीं है कि जैसे कई जगह पे क्या होता है, हम आगे क्वेश्चंस में देखेंगे दैट यू आर एबल टू अप्लाई कॉन्सेप्ट्स. कि मान लो अगर आपको नहीं आता है ना कुछ भी, तो यू आर लाइक अच्छा ये हुआ होगा, ये ऐसे होता है, वैसे होता है, दे हैव सर्टेन बेसिक फीचर्स, सर्टेन बेसिक प्रीमाइस जहाँ पे होता है. लेकिन व्हेन इट कम्स टू क्वेश्चंस लाइक दीज, ऐसा नहीं होता है. ये वाले क्वेश्चंस, ये वाला एरिया इज सो ट्रिकी एंड इट हैज़ टू बी मक्ड अप, and it is important not for your polity but for your history as well. So you have no choice. And in case you are willing to um, see the video, I have recorded a video. It is an old video, it's not a new one. You can go and check out on the channel under fast track revision course. There are two videos available under that course, and it's a quite an old video, so you can go. But वहाँ पे I have taken in the very first lecture only, I have taken the historical development, so you can go and watch that. The fast track program for 2026 प्रीलिम से 6-8 महीने पहले हमने बनाया था. ठीक है. तो उसके दो लेक्चर्स अवेलेबल हैं वहाँ पे फ्री ऑफ कॉस्ट. आप पहला लेक्चर अगर जाके देखते हो तो वहाँ पे वी हैव टेकन दैट. ओके. सो दैट विल बी गुड. ठीक है. नाउ let's go to second question. Second question is, consider the following statement regarding the Government of India Act 1935 and Indian Independence Act of 1947. The Government of India Act 1935 abolished the system of diarchy entirely from Indian administrative structure in order to establish autonomous units of administration. ठीक है. The second statement is, the Indian Independence Act of 1947 ended British suzerainty over princely states, granting them legal freedom to remain independent rather than maintaining the integration into either of the dominion. Now, if you see the very first statement, it is saying diarchy entirely from the Indian administration system. So, not whether it doesn't apply to coachings as well, coachings, but if you talk about UPSC, and that is what we are trying to replicate here with Manika, I guess, is with UPSC, what happens is when you see a very absolute statement, 99% of the time, that absolute statement is always incorrect. And that is the only statement which is incorrect in the options given. That is why I also marked this answer question as easy question, because ek to it is factual and it is very much known that 1935 ने abolished diarchy नहीं की थी entirely. They abolished provincial diarchy. ठीक है? So it's a very conceptual, bookish knowledge वाला question है, factual question है, but it is not a tricky question as such. ठीक है? So it's very basic. That's why the correct answer here is B, and you must be knowing about it. Then comes your question 3, which is with respect to making of constitution. Making of constitution is another such area which has to be mucked up. So initial जो पॉलिटी के कुछ areas हैं वो बहुत ऐसे हैं कि आपको याद ही करना पड़ेगा, ठीक है? So consider the following pair of key personality and their respective roles in Constituent Assembly. Okay. So B.N. Rao, Constitutional Advisor, Jawaharlal Nehru, Chairman, Provincial Constitutional Committee, H.C. Mukherjee, Vice President of Assembly, Dr. Rajendra Prasad, Chairman, Drafting Committee. ओके सो इसके अंदर हमें क्या मैच करना है कि कौन सा करेक्ट है कौन सा इनकरेक्ट है सो द easiest loophole here is Dr. Rajendra Prasad, chairman of drafting committee. We all know the chairman was not Rajendra Prasad, is it was B.R. Ambedkar. ठीक है so this is incorrect. And the second loophole here is आप देखो प्रोविंशियल कॉन्स्टिट्यूशनल कमेटी के जो चेयरमैन है वो जवाहरलाल नेहरू हैं ही वॉज द प्राइम मिनिस्टर एट दैट पॉइंट इन टाइम आफ्टर इंटरिम प्राइम मिनिस्टर बोल सकते हो आप ठीक है नाउ द थिंग इज द प्रोविंशियल कॉन्स्टिट्यूशनल कमेटी के चेयरमैन सरदार वल्लभ भाई पटेल थे एंड इसका लॉजिकल डिडक्शन क्या है इसकी लॉजिकल डिडक्शन ये है बिकॉज ही वॉज द वन हु वॉज रिस्पॉन्सिबल वॉज काइंड ऑफ अ होम मिनिस्टर सो ही वॉज द वन हु वॉज रिस्पॉन्सिबल टू ब्रिंकिंग इन ऑल द प्रोविंसेस टुगेदर ऑल राइट वेर एज जवाहरलाल नेहरू वॉज अ यूनियन कॉन्स्टिट्यूशनल कमेटी के चेयरमैन थे ठीक है सो द करेक्ट आंसर हियर इज ओनली टू पेयर्स बी ठीक है सो Jawaharlal Nehru, Union Powers Committee. H.C. Mukherjee was Vice President. B.N. Rao, Constitutional Advisor. Dr. Rajendra Prasad, President of the Assembly. Now, do you notice one thing that easiest options were incorrect? ठीक है? In the sense, not easy, the known faces were incorrect. ठीक है? So this is where UPSC also test you. वो कोई ट्रिकी सा स्टेटमेंट ला के नहीं डालेंगे ठीक है लेकिन ट्रिकी के अंदर एक आधा ऑप्शन आप इजी वाले को डाल देते हैं एंड वहां पे आपको टेस्ट करना होता है जस्ट अ सेक ओके तो let's start with question number 4. Consider the following pair regarding the borrowed features of Indian Constitution and their respective sources. So very first is your Irish Constitution, nomination of members to Rajya Sabha. Then is South African Constitution, election of members to Rajya Sabha. यहाँ पे nomination है, यहाँ पे election है. Australian Constitution, advisory jurisdiction of the Supreme Court. American Constitution, cabinet system. ठीक है. So the thing is, first and second are correct. Again, this is very factual thing. There's nothing अगर अगर आपको याद नहीं है तो आप उसको डिड्यूस नहीं कर सकते ठीक है इट हैज़ टू बी नोन इट हैज़ टू बी लर्न इट हैज़ टू बी मक्ड अप सो दीज आर द एरिया which need rote learning that you have no other options you have to go for ratifying these points ठीक है so Irish Constitution say we have taken directive principles of state policy method of election of president and nomination of members of Rajya Sabha. South African Constitution say we have taken the procedure for constitutional amendment and procedure for election of members of Rajya Sabha. Australian Constitution say we have taken concurrent list, freedom of trade and commerce, and provision for joint sittings, whereas the advisory jurisdiction of Supreme Court has been borrowed from Canadian Constitution. And American Constitution से Indian fundamental rights, judicial review, impeachment process and cabinet systems of government तो हमने लिया है ब्रिटिश से, ठीक है? So हमारा parliamentary system is essentially from British only, ठीक है? Now let's see the salient features. यहाँ से आपके थोड़े application based questions भी शुरू हो जाएंगे, ठीक है? The fifth question is the Indian Constitution established a federal system with the pronounced unitary bias. Based on this, which of the following statement is incorrect? ठीक है? Statement one is the Constitution established a dual government system consisting of center and state. India follows a system of single citizenship for all its citizens across the country. The governor of the states are appointed by president and act as an agent of center. The residuary power of legislation are vested entirely in the state government. Now, all these three statements are correct, and it is actually establishing how the Indian government works. But when you see the statement D, the residuary powers are with the central government. They are not with the state government. ठीक है? So the correct answer here is option D. Then comes your question number. Now, this was an easy question that you should know because बहुत basic structuring है constitution की, and it is very obvious कि India के अंदर we do have single citizenship, we don't have dual citizenship, and as a citizen we also know that we have single citizen, right? The governors are appointed by president, and all of these features are actually to ensure that you have a strong center. ठीक है. And why India essentially wanted a strong center? India wanted a strong center. India didn't wanted it to balkanize in the form that Europe did after the war. So India का क्या था? Balkanization नहीं चाहिए हमें इंडिया का. We want a strong center that can hold all the states together so that we can ascertain sovereignty and we can grow. ठीक है. Because after the partition with Pakistan, we had seen कि how much bloodshed it led to. So India actually wanted a very strong center. हमेशा इंडिया का कॉन्स्टिट्यूशन ऐसे ही है that you have a strong center. So that was the basic principle. All right. Then come question number 6, which is consider the following statement regarding distinction between written and unwritten constitution. In a polity with an unwritten constitution, there is fundamentally no legal distinction between ordinary laws and constitutional laws. Now that is correct. So a written constitution inherently mandates a rigid amendment procedure, ensuring that no provision can be amended by a simple legislative majority. See, although written constitutions are little difficult and rigid to amend, ठीक है? Because अगर वो easy amendability होगी तो वो कैसे भी amend कर सकते हैं. तो written constitution के हमेशा laws होते हैं that can not be easily amended. That is correct. तो but it is not always mandatory कि rigid ही हो. जैसे if you see Indian Constitution, it is blend of easy and difficult rigid amendment. ठीक है? So that is why the statement 2 is little absolute statement, and that is why this particular statement is incorrect. Okay. Then third statement is the scope of judicial review is generally wider in a country with a written constitution because the constitution act as a supreme codified touchstone for testing validity of legislative act. Now this is generic statement, this is correct. This is what the basic principle of written constitution is. So the correct answer here is 1 and 3. Rest of the statement, the second statement is incorrect. Then come to question number 7. Now the question number 7 says a truly Mr. X. Now this is a conversation kind of a thing. These are the kind of question that UPSC added in this year prelim. So we have tried to incorporate that from the very first test onwards, so that you have a tendencies of solving those questions. So the very first argument is a truly secular state require a strict wall of separation. The government must never fund religious schools, subsidize pilgrimages, and allow religious symbol in a public office. The state must remain completely blind to religion. ठीक है. Now the second argument is That is too rigid for our society. Secularism means principal distance. The state respect all faith equally, but it can and must interfere religious practices to eradicate social injustice while still providing equitable support to minority institutions. Okay. Now, this is what it is testing is your concept of secularism with respect to India. How is Indian secularism? Direct question भी पूछ सकते थे, लेकिन because UPSC is trying to test you on the basis of your focus and attention, so they are changing the nature of questions to these kind of questions, and it also check your aptitude. ठीक है, so now aptitude is also checked in these questions, GS, not only your CSAT. ठीक है, so that is why this kind of question is there. And if you see what, based on the brief conversation above, the constitutional philosophy of India, which of the following inferences is correct? हमें figure out करना है कि कौन से correct है. So Mr. X view accurately reflect Indian constitutional mandate, which strictly prohibit the state from engaging in any religious affair to maintain absolute neutrality. ठीक है. Second is Mr. Y concept of principal distance implies that state must treat all religion with equal inference, leaving communities completely free to self-regulate. So the one is saying absolute neutrality, so we do not have absolute neutrality. So statement one is incorrect. Now statement B is saying it is implying कि state को सब religion को equally छोड़ना, equally treat करना है, and communities should self-regulate. Now this is also not Indian secularism is. It is not that कि there is like a principal distance कि अपना religion खुद संभालो. No, country does interfere. Indian secularism means there is a passive kind of a control. ठीक है. So while Mr. X advocates for a model based on mutual exclusion, Mr. Y model permits the state to actively intervene in religious affairs to protect fundamental constitutional values like equality and dignity. Now, this statement is correct as of now, ठीक है. बट कभी भी ऐसा क्वेश्चन होता है तो डू नॉट जस्ट मार्क द स्टेटमेंट बिफोर रीडिंग द नेक्स्ट स्टेटमेंट. ओके, so what you should always do is once you have identified, do go and read the next statement, because in prelims also it is very evidently written on UPSC paper that you have to figure out which is the best correct answer. You can have two correct statement, but उसमें से भी you have to identify which is the best correct answers. ठीक है. So the D point is the conversation illustrates that both models ultimately aim to assimilate diverse religious identities into single uniform civic identity to prevent communal disharmony. No, it's not like that. We don't have a uniform civil con kind of a thing. We So the statement C is correct. Your answer is C. Okay. Now let's move to question number 8. Consider the following statement regarding the role of constitution in a democratic polity. Statement 1. In a constitutional democracy, the most fundamental function of a constitution is to limit the power of state, ensuring that the government can never function as a legal omnipotent entity. Statement 2. The Constitution explicitly guarantees certain fundamental rights to its citizen, establishing structural boundaries that the legislature and executive can never validly trespass, even if they possess an overwhelming electoral mandate. So here, both the statements are correct, and statement 2 is the correct explanation for statement 1. So basically, the purpose of constitution is to draw boundaries on the government as well. ठीक है? So that the constitution remains the same, because in India what we have is lex supremus. ठीक है? And secondly, ये एक आंसर्स आपके ना, अगर आपने बुक पढ़ी है आर कॉन्स्टिट्यूशन एट वर्क, देन यू विल बी एबल टू सॉल्व. ठीक है, बिकॉज वहाँ पे चैप्टर में क्लियरली ये पॉइंट्स लिखे हैं. दैट इज वाई द रेलिवेंस ऑफ एनसीआर, दैट इज वेयर द रेलिवेंस ऑफ एनसीआरटी कम्स इन. See, books like Lakshmikant and Spectrum, they are so good, they are well written, they are to be read for exam point of view. Otherwise, there is no single source where you can cover that much amount of factual information. But when it comes to NCRTs gives you the conceptual clarity that these books will not give you, because they are fact driven. NCRTs are concept driven. Although the facts, these concepts are also mentioned in the books like Lakshmikant, ठीक है? But at the same time, it is not primarily a factual, conceptual book. It is primarily a factual book. ठीक है? That is where the relevance of NCRT comes in. So do read it. It's very easy. The language is very easy. You will be able to cover it in a day or two. Okay, so do read it. Read it. This will be very helpful to you. So the answer here is A. With that, let's move to the next question, which is, which of the following group of words were added to preamble of the Indian Constitution by 42nd Constitutional Amendment Act 1976? ठीक है. Now, the options given are sovereign, socialist, and secular. Option B is socialist, secular, integrity. Option C is liberty, equality, and fraternity. Option D is justice, liberty, and republic. Now, with the very basic common sense, you tell me what is the issue? Why, when India became the country, what was the primarily issue? That they were ruled by Britishers. So, what they wanted to assign? They wanted to assign self rule. तो सोवरेनिटी तो उसी टाइम डालेंगे ना, 1976 में क्यों डालेंगे? ठीक है, वो तो तभी डालेंगे, तो सोवरेनिटी तो हो नहीं सकता. दैट एलिमिनेट ऑप्शन ए. ठीक है. Now, if you see option C is also that you need to have liberty, you need to have equality, because that was the craving at that point in time, that we were treated inferiorly, okay, and they were being like superior beings and we were inferiors. That is the treatment we got, the slavery treatment. So what was our core demand? The core demand was to have our own freedom, to have our own equality, okay. So that is C. Now, if you see D is also having one option, which is justice, liberty को तो छोड़ देते हैं, चलो एक बारी. Although liberty also counts, as we have discussed for C, republic. Now, these kind of terms ना, you can think कि those were the essential demand कि हमें एक independent country create करना है. तो the likelihood is कि those points will be added to the preamble before hand only. They would not wait for another 25 to 30 years post the uh, 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 independence to give the add these words to the preamble of constitution. This could not be the true. But if you see these things, socialist, secularity, integrity, they always come secondary to sovereignty. Okay. So that is why what we are saying here is the most potential answer is B, even if you have not read it. But what you have to do here is you have to read it, and you have to do this analysis, your reasoning in your head when you are reading it. You can't be doing this kind of analysis just on the day of paper. That is why practicing questions is very important, and giving test is more important, and analyzing test is the most important thing that you have to do with respect to your preparation for preliminary examination. Okay. Then comes question number 10. According to the text of the preamble, on which exact date did people of India adopt, enact, and give themselves to the constitution? So it's simply asking you कि preamble के अंदर कौन सी date लिखी हुई है. So the correct answer here is 26 November 1949, unlike the presumption that because on 26 January 1950 we have our independent Republic Day. So, but the correct answer here is 26th November 1949. Okay. Then come your question number 11. In the context of political theory and democratic polity, which one of the following most appropriately describe the true essence and substantive meaning of liberty? Now, this question has been taken from your PYQ. If I'm not wrong, this question was asked in your 2018 or 2019 maybe. Okay. So this is from there it was taken. And the option one is complete absence of external restraint and coercion by the state on individual actions. The conditions that provide necessary and adequate opportunity for holistic development of individual personality. C, the unrestricted freedom from citizens to express the desires and act entirely according to their own will. D, the structural protection of minority groups against tyranny of political majority. ठीक है, so सबसे पहले हम D को eliminate करते हैं because D is basically just for one particular group. That cannot be the true definition of liberty. So D gets eliminated. Now comes A, B, and C. If you see the statement A, it is saying complete absence of external restraints and coercion. ठीक है. Option C says the unrestricted freedom to express their desires. Now, both of them are essentially saying one thing, which is there is like my life, my rules. Okay. But does that work in real sense? It never work. It will never work. That's not true liberty. Because if true liberty means it is because it is my life, my rules, I can do whatever I feel like. There is no external restraint on me. Then that applies to the other person also. Correct. So, say for example, if somebody is a criminal, somebody is a murderer, right? Somebody kills, saying it is my life and liberty, I can do whatever I feel like. How am I wrong? This is my liberty, right? But that's not how it works now because your liberty has taken somebody else's life. So, liberty in true sense can never be accomplished. Otherwise, it will lead to a chaotic and a jungle raj kind of a thing unless and until you have external restrictions on it. So your liberty is there unless you try to harm somebody else, you messes with the public order, you go against the sovereignty of the country. Till the time you are in your boundaries and you're not crossing your lines, you have your liberty. And that is what true liberty means. That is where all people can grow together. That is why the correct answer here is B, where you have opportunity to get adequate opportunities for holistic development of an individual personality. ठीक है, that is the true essence of your liberty. ठीक है, unrestricted freedom is not equal to freedom, it's equal to chaotic rule or a jungle raj. Please make this point very clear in your head whenever you are reading, and this question was asked in 2018 or 19 if I am not wrong. ठीक है, so next come your question number 12. Consider the following statement regarding the legal and constitutional status of preamble to the Constitution of India. This is one of the most important topics in order for you to understand the connection of preamble with the Constitution. So you must be very well clear with it, and there are number of rulings of Supreme Court in this regard. You must not know about the rulings, but you should know about the essence. In your mains answer, if you get a question, you should know the name of one or two cases that would be sufficient. Okay. So, the very first statement is while preamble reflects the fundamental values and grand philosophy of the constitution, the judiciary cannot strike down a law passed by parliament merely on the ground that it violates the spirit of the preamble. Now, this statement here is correct because preamble is not the source of power, it is just a preface to the constitution. That is why. Now, statement 2 is the preamble is non justiciable in nature. It is neither a source of substantive power to legislature nor a limitation upon the powers of legislature. That is also correct. It is just the preface. It is laying down the values, the basic principle that India should be moving towards in order to get to the epitome of what it wants to be. Okay? That means you are a sovereign republic, you are socialist republic, you are a secular country, you have equality, liberty, justice, fraternity, these kind of things you have. Okay? Now this is what describe how the nature of polity India should be, but it never says that these are the things that you should be like these are justiciable. You cannot go to court अगर preamble का enforcement नहीं हो रहा है. You can go to court अगर उससे related कोई भी constitutional provision constitution के अंदर है, then you can go to court. But you can just on the basis of preamble you cannot go to court because it is not justiciable in nature. ठीक है, this is what we call at conceptual understanding that you must be having. So the correct answer here is A. Now, 13 is question number 13 is consider the following statement regarding Article 1 of Indian Constitution. ठीक है. The Constitution officially recognizes both India and Bharat as the names of country. That is correct. India, that is Bharat. ठीक है. Second is the phrase Union of States implies that Indian Federation is the result of a voluntary agreement among the constituent states. Third is according to the Constitution, the states have the right to secede from the Union if they choose to do so. The territory of India is a broader concept that includes not just state and union territories but also any territories India may acquire in future. ठीक है. Now, यहाँ पे if you see statement 2 and statement 3, what we had discussed a few minutes ago, that India wanted a strong center because they want to India to keep united. ठीक है. And you had specifically provincial committee because you wanted to bring all the provinces together in order to form one union of India. ठीक है. And that is why Sardar Vallabhbhai was made the chairman of that particular committee. What does that imply? India is not a voluntary agreement of all the state to come be in India. ठीक है. It is not a voluntary. They did never came voluntarily. ठीक है कि सबका नहीं है voluntary. Most of them were voluntary, but not all of them. ठीक है. And this is the exact difference between union and federation. That union is loosely tied. That means if you see USA, the states in USA have a right to secede from USA. But states in India do not have a right to secede from USA. इन इंडिया की स्टेट कोई भी वॉलंटरी इंडिया को छोड़ नहीं सकती यूनियन को यूएसए में बिकॉज यू हैव यूनियन ऑफ स्टेट इंडिया इज अ फेडरेशन ऑफ स्टेट सॉरी इंडिया इज अ यूनियन ऑफ स्टेट एंड दैट इज फेडरेशन ऑफ स्टेट तो यू कैन नॉट लीव इंडिया ठीक है तो इससे सीड नहीं कर सकते आप तो दिस सेकंड स्टेटमेंट एंड थर्ड स्टेटमेंट इज इनकरेक्ट because we wanted to prevent balkanization as we had discussed previously. Okay. And the statement 4 and 1 is correct. India, that is why Sikkim could come to India. Okay, because under the territory of India is a broader concept, and we wanted to include the territories that India may acquire in future as well. Okay. Constitutionally, that is why statement 1 and 4 are correct, and right answer here is your D. Come to question number 14. With reference to the reorganization of state under Article 3 and Article 4 of Indian Constitution, consider the following statements. The constitutional obligation of the president to refer a boundary altering bill for consultation applies equally to both full-fledged state and union territory that poses their own legislative assemblies. No, this is incorrect. Union territories को नहीं apply करता because union is a territory of center only ना UT. So that is why it applies only to states. It doesn't apply to union territories. So first statement is incorrect. Second is any law enacted by parliament to diminish the area of a state automatically trigger an amendment to first and fourth schedule. Correct. Yet this alteration is legally executed without invoking the constitutional powers of parliament and under Article 368. Now this statement is also correct. ठीक है. If Parliament introduce a substantive amendment to a state reorganization bill after receiving the initial views of state legislature, the president is constitutionally obligated to refer to newly amendment bill back to state for fresh reconsideration. This statement is incorrect. President is not obligated. ठीक है. This statement is incorrect. First is also correct. Second is correct. Now, with respect to second, I have question to ask you. Despite of the fact there is no constitutional amendment needed to add in schedule 1 and schedule 4 ठीक है but why is it we do have a constitutional amendment ठीक है why do we have that have you heard of something called Berubari judgment have you read that So I am giving you a homework in the comment section. You will tell me why, if this was not the case in Berobari judgment, in secession of its territory in land boundary agreement with Bangladesh, why India needed a constitutional amendment with special majority. Why it needed that? You will comment that in the comment section, and we'll discuss it tomorrow, and we'll be discussing the remaining half of the test. Okay. With that, let's move to question number 15. Now, this is with respect to citizenship. Consider the following statement regarding framework of citizenship in India. Similar to union state, Indian constitution provides for dual citizenship system, where an individual is a citizen of both the country and specific state they reside in. Now, India, as we have discussed earlier also, do not have a dual citizenship system. India have a single citizenship. So, USA ke andar, if you will see, they have a state citizenship also and they have a center citizenship also. But with respect to India, we do not have state citizenship. ठीक है? So that is why your statement 1 is incorrect. The statement 2 says power to enact laws regarding the acquisition and termination of citizenship is vested exclusively in Parliament of India. This statement is correct with respect to statement 1 only we can identify कि why Parliament के अंदर है because citizenship के rights center के पास है ठीक है तो statement B is correct. Now is this is the scenario, why do we have domiciles? Don't you think domicile also act like a citizenship का status for a particular state? We do have domicile certificate होता है ना? अगर आप state PSC का एग्जाम दे रहे हो आपको लगेगा state domicile certificate of that particular state. Why is that? Tell me why is that? The reason being domicile is the document essentially to bypass dual citizenship. पर्पज ही यही है उसका सो दैट अगर कोई स्टेट स्पेसिफिक सोशल स्कीम निकाली गई है उसका बेनिफिट उसके स्टेट के लोगों को मिल सके उसके लिए दे वांटेड अ डॉक्यूमेंट एंड दैट इज व्हाई इट इज कॉल्ड अ डोमिसाइल डॉक्यूमेंट इट इज नेवर सेज कि सिटीजनशिप डॉक्यूमेंट ठीक है the purpose of this domicile is essentially to target the state policies and state beneficiary schemes to that particular state residents. That is the purpose of domicile. ठीक है it is essentially to cater to the inevitability of dual citizenship basically. ठीक है so that much of conceptual clarity you must have. Now, question number 16. With reference to acquisition of Indian citizenship under Citizenship Act 1955, consider the following statement. Children born in India to foreign diplomats posted in country automatically acquire Indian citizenship by birth. This is incorrect. ठीक है although by birth citizenship मिलती है but the enemy aliens and the foreign envoys are they are not exception to that particular category. Then come question number point number 2. A foreigner applying for citizenship through naturalization is required to have adequate knowledge of a language specified in 8th schedule of Indian Constitution. This is correct statement. ठीक है statement 3 is if a foreign territory is incorporated into India, all the inhabitants of that territory automatically become citizen of India on that day of incorporation. Interestingly, this statement is incorrect. This means Parliament will say and will maybe bring up a law कि किसको citizenship मिलेगी किसको नहीं मिलेगी who will get the citizenship who will not get the citizenship among the one in the acquired category. ठीक है so this was why you have correct answer here is only one. Then let's start the discussion over the questions of fundamental rights. Question number 17. Under Article 30 of Indian Constitution, the right to establish and administer educational institution of their choice is guaranteed to which of the following categories? Very factual, very basic question, very straightforward question. The answer here is both religious and linguistic minorities. सो यू बेटर रीड द फंडामेंटल राइट्स अगर आपको नहीं आता है इसका मतलब यू गो टेक योर बुक टेक योर बेयर एक्ट टेक योर लक्ष्मीकांत रीड रिवाइज दैट्स द ओनली ऑप्शन ठीक है then you have question number 18, which is with reference to Article 17 of Indian Constitution, which abolishes untouchability. Consider the following statement. The Constitution explicitly defined the term untouchability to ensure that judiciary has clear boundaries for enforcing penal provision. ठीक है भाई now, second is the fundamental right against untouchability is available only against state and its instrumentalities, not against private individuals. The third statement is the power to enact prescribing punishment for the practice of untouchability is vested exclusively in parliament, denying state legislature any power in that regard. ठीक है, तो correct answer here is 3. Now, with respect to this question, I want to tell you how do you apply your basic common sense and knowledge. ठीक है, जहाँ पे अगर आपने नहीं भी पढ़ा है तो आप कैसे अप्लाई करोगे, मान लो आपको ये नहीं आता है. Now the very first thing is कॉन्स्टिट्यूशन कुछ भी एक्सप्लेन नहीं करता है. इट नेवर गिव्स यू अ डेफिनेशन ऑफ एनीथिंग. इट विल ड्रॉप वर्ड्स. डेफिनेशन कभी कॉन्स्टिट्यूशन से नहीं आएगी किसी चीज की. ठीक है, सो योर स्टेटमेंट वाज वन इज इनकरेक्ट विच सेज it explicitly define the untouchability. It will never define anything. और इतना बड़ा कंट्री था, इतने सारे लोगों को, इतने सारे डाइवर्स कल्चर को हम साथ लेके आ रहे हैं. ऑलरेडी हमारा इतना लेंथीएस्ट कॉन्स्टिट्यूशन है, तो व्हाई वुड कॉन्स्टिट्यूशन केयर अबाउट डिफाइनिंग? दैट्स नॉट द जॉब ऑफ द कॉन्स्टिट्यूशन. So if anybody says this is defined in constitution, nothing is defined in constitution. ठीक है, first statement is incorrect. Now second statement is कि fundamental right against untouchability is available only against state and its instrument and not against private individual. Now by sheer common sense you have to tell me अनटचेबिलिटी प्रैक्टिस कौन कर रहा होता है? अनटचेबिलिटी कौन प्रैक्टिस कर रहा था? It was the people who were practicing untouchability. It was not state who was practicing that at that point in time. If somebody is being treated differently, somebody is being treated inferior, somebody is being asked not to sit on the same table, not to eat food from the same area, not to have water from the same pond, not to live enter the house, whenever entering the villages, beat drums so that we know you are coming and nobody comes near to you. Who is doing that? It's the people. So if the perpetuators are the people, it is mandatory that if you want to abolish a particular sin, particular evil, that the law has to apply against individual as well. So it doesn't need a lot of uh, knowledge for you to figure out कि ये प्राइवेट इंडिविजुअल के अगेंस्ट अगर हम अनटचेबिलिटी को इन्फोर्स नहीं करेंगे तो फिर इसका फायदा ही नहीं है. स्टेट तो वैसे भी नहीं कर रही है, मेजोरिटी तो कौन कर रहा है? पीपल ना. सो इट हैज टू बी अप्लाइड अगेंस्ट प्राइवेट इंडिविजुअल्स एज वेल. ठीक है, so this is how you apply your basic common sense even when you don't know the answer. So statement 2 here is incorrect. ठीक है, it is available against private individuals as well. So the right answer here is 3. Now, which one of the following pairs of constitutional writ is literal meaning is incorrectly matched? ठीक है. Now, there are 4 things: habeas corpus, mandamus, quo warranto, and prohibition. Habeas corpus is saying to have body of. Mandamus is saying we command. Quo warranto is saying to be certified. Prohibition is saying to forbid. Now, which one of this incorrectly match? ठीक है. Now, आई एम गिविंग यू अ चीट कोड बिकॉज आपको इसको याद करना पड़ेगा. इट इज इन देयर नेम. अगर किसी को नहीं भी याद होता है ना कि क्या डिफिकल्टी है. नाउ लुक अबाउट हेबियस कॉर्पस. कॉर्पस इज व्हाट? कॉर्पस इज बेसिकली अ डेड बॉडी. ठीक है, अगर आपको टर्म का मीनिंग पता है तो इट सिंपली मीन्स टू हैव बॉडी ऑफ. मैंडेमस का मतलब क्या है? मैंडेमस इज, लुक इन द वर्ड मैंडेट. ठीक है, वी कमांड. दैट इज वाई इट इज लाइक mandate क्या है? Why, what command you are, what is the command, right? So that is why B mandamus से command is driven. Just a sec. ठीक है, then the third is your quo warranto. Warranto itself saying by what warrant, by what authority are you doing this? That is why it is not to be certified. Certified कहाँ से आएगा? सर्शोरारी, नाम ही सेम है यार. नहीं याद होता है तो देख लो. सर्टिफाइड, सर्शोरारी, पहले की 4 अक्षर सेम है इस तरीके से. देन प्रोहिबिशन, प्रोहि मतलब रोकना, एंड दैट इज बाय टू फॉरबिड लोअर कोर्ट टू डू एनीथिंग. सो रेस्ट आर द 3 आर करेक्ट. को वारंट इज रॉन्ग. राइट आंसर हियर इज सी. So this is what you have to do and this is what is called active reading and recall. Active reading. अगर आप पैसिव रीड कर रहे हो तो यू विल रीड अच्छा हेबियस कॉर्पस का मतलब ये होता है, अमेंडमस का मतलब ये होता है, को वारंटो का मतलब ये होता है. लेकिन अगर आप एक्टिव रीडिंग कर रहे हो तो यू आर, योर ब्रेन इज अलर्ट एंड यू लाइक अच्छा मतलब इसका तो सेम ही इस वर्ड से डिराइव कर लेंगे, रटने की तो जरूरत ही नहीं है। द पर्पस इज टू रिमेंबर बाय लेस रोटोइंग मोर अंडरस्टैंडिंग, बिकॉज ऑलरेडी बहुत सारा सेक्शन है जिसको रटना है, ठीक है। तो हमारी कोशिश क्या करेगी कि जिस चीज को हम अपने नॉलेज के हिसाब से ब्रेक डाउन करके समझ सकते हैं ताकि हमें कम रटना पड़े, डू दैट। दैट इज द पर्पस ऑफ एक्टिव रीडिंग, ठीक है। दिस विल हैपन इन योर सेकेंड रीडिंग। इन फर्स्ट रीडिंग जस्ट ट्राई टू अंडरस्टैंड थिंग्स, ठीक है। Then Article 19 of Indian Constitution guarantees certain basic freedoms to all citizens. Which of the following is currently not a fundamental right protected under Article 19? Article 19 के अंदर कौन सा right नहीं है? The one is freedom of speech and expression, freedom of to form associations and unions, freedom to move freely throughout the territory of India, freedom to acquire, hold, and dispose of property. Now, here the right answer is D. ठीक है, that right to property was once a fundamental right, was removed and put into as a legal right. And why did they do so? The reasoning being, during the phase before independence, a lot of influential people, lot of जिसे आप top 1% बोल सकते हो, had acquired immense amount of land. But in the DSPs, you and as a socialist government, what India wanted was to have equal distribution of land. To that is why, and to create an infrastructure as well. So they wanted to acquire lands, take away land, and redistribute land from such people to everyone. And that is where you wanted a key fundamental right now, right to property. And that is why it was taken out from the fundamental right and put under Article 300A as a legal right. Okay. Then comes question number 21. Consider the following statement regarding the writ issuing powers of Supreme Court and High Courts. Article 32 and Article 226. Okay. Now the Supreme Court has wider writ jurisdiction than High Court because it can issue writs not only for fundamental rights but also for other ordinary legal rights. Second is the territorial jurisdiction of Supreme Court for issuing writ is wider than that of a High Court. Does that make sense? हाई कोर्ट जिस एरिया का हाई कोर्ट है उसमें करेगा, सुप्रीम कोर्ट पैन इंडिया के लिए कर सकता है, तो दैट मेक सेंस. आर्टिकल स्टेटमेंट 2 is correct. Now statement 3 is Article 32 is a fundamental right itself. The Supreme Court may not refuse to exercise its writ jurisdiction, whereas the remedy under Article 226 is discretionary of a High Court. Now this is also correct. Statement 1 is incorrect, and I'll tell you why, because it is exact opposite. Writ jurisdiction of Supreme Court is not wider than High Court, because Supreme Court सिर्फ fundamental rights के ऊपर writ jurisdiction लगा सकते हैं Supreme Court के अंदर. But High Court का wider है because High Court can do it on ordinary legal rights as well. That is why statement 1 is incorrect and 2 and 3 both are correct, and correct answer here is B. ठीक है. Then comes your question number 22. Consider the case study. Mr. X, a popular stand up comedian known for dark humor, appears on a prominent digital podcast hosted by Mr. Y during an unscripted conversation. He makes a satirical, edgy joke regarding a sensitive cultural topic. The clip goes viral, outraging a specific community who claim their sentiments are being hurt. Several FIRs are filed against Mr. X and Y demanding their arrest on the grounds that their content threatens public order and violates decency and morality. Mr. X approaches the court, argues that as a comedian, his satire is protected under fundamental rights. ठीक है. Now we do have a freedom of speech and we do have freedom to cinema under freedom of speech and expression. ठीक है. And this is where the freedom comes of comedians also to crack a joke. So why that this is such a big deal? Let's break it down. In the context of Article 19 and relevant Supreme Court judgment, consider the following statement regarding the above example. The one is right to freedom of speech and expression includes freedom of the press and the right to broadcast podcast on digital platform. ठीक है. ठीक है, that's fine. Satiric and comedy expression enjoy absolute constitutional protection and cannot be penalized solely on the ground that they are offensive and unpopular to a section of society. So they don't have an absolute immunity. So this statement is incorrect. Then comes the third statement, which says, for the state to legally restrict Mr. X joke on the ground of public order, there must be a direct and proximate nexus between the joke and an actual incitement to violence and public disorder. Okay. So, what Supreme Court essentially said that there has to be intent, also has to be understood, because a joke is a joke and sometimes some people might not like a joke, but if the intention of the person who is making the joke is to uh, create uh, kind of a public actual incitement to violence karna and create a public disorder, then that person could be behind the bars, otherwise that person is free to go. ठीक है, that comes under is freedom to right of speech and expression. So correct answer here is B, 1 and C we all know somewhere है ना. ठीक है. Then, with reference to the definition of state under Article 12 of the Indian Constitution, consider the following statements. The definition of state provided under article applies universally to all provisions throughout the Constitution of India. ठीक है. Now, this statement is incorrect. आर्टिकल 12 के अंदर जो स्टेट की डेफिनेशन है, इट अप्लाइज ओनली टू फंडामेंटल राइट्स एंड टीपीएसपी. इट डजंट अप्लाई टू any other part in the constitution. So first statement is incorrect. Second is, according to the Supreme Court, a private body or agency working as an instrument of government falls within the meaning of state. Third is, the Board of Control of Cricket in India is classified as a state under Article 12 because it performs a public function of regulating a national sport. So second statement here is correct and third statement is incorrect, because देखो second statement में क्या है, although it's a private body, but if it is working for the under the government, say for example आधार कार्ड बने सबके, so Aadhaar centers के अलावा there were private people also who were working to make Aadhaar cards, ठीक है. So at that point in time, they have to follow the rules and definitions which are available for under, they fall under that particular time for our under state. ठीक है. So that is why your statement 2 is correct and statement 3 is incorrect, because uh, in the judgment of Z Films Limited and Union of India 2005 case, the Supreme Court ruled BCCI is not a state under Article 12. Where it does perform certain public function, it can be called to writ jurisdiction in High Court under Article 226. It is not financially, functionally, administratively dominated by government enough to classify it as an instrumentality of state under Article 12. That is why the statement 3 is incorrect. Then comes your question number 24, which is, the court cannot interfere here. It's something being said by Mr. X. Again, this is a conversation wala question. ठीक है. We did not pass a proper act in the assembly. We only issued an executive order to ban this book. And this ban is based on an old community custom. Therefore, Article 13 does not apply to us. ठीक है. Then the citizen lawyer, which says, this is wrong. Article 13 is broad enough to cover both your executive order and your custom. If they violate fundamental rights, the court can strike them down. So, what is Article 13? Article 13 basically define law. ठीक है, कि किस किस लॉ के ऊपर देर इज अ अमेंडमेंट जो बन सकती है या फिर कोर्ट एक्ट कर सकता है. ठीक है. So the statement 1 here is, based on the constitutional text of Article 13, consider the following statement regarding the arguments made. Mr. Y is correct about executive order because Article 13 clearly states law include government orders, rules and notification. ठीक है. Mr. Y is correct about customs because Article 13 explicitly includes any custom or usage that has a force of law. So both these statements are correct. Article Statement 3 is, if Parliament passes a constitutional amendment to ban this legal, the written text of Article 13 state the amendment will also be treated as a law and can be struck down. ठीक है. So this is incorrect. And why so? Let's see. Now, The actual written text of Article 13.4 says a constitutional amendment is not a law under this article. ठीक है, so that is why constitutional amendment नहीं इसके अंदर आता है आर्टिकल 13 के अंदर, and the right answer here is B, only two options. ठीक है. What about question 25? Let's discuss. With reference to right to equality under the Indian Constitution, consider the following statement. While Article 15.1 prohibits the state from discriminating against citizens on ground only of religion, race, caste, sex, or place of birth, Article 16, Clause 2 explicitly add descent and residence as additional prohibition ground specifically for matters of public employment. Now, this statement is correct. This is different that you must know कि वहाँ पे ये descents और residence के grounds भी available हैं. ठीक है. The concept of equality before law enshrined is a positive concept borrowed from American Constitution, which mandates state to take affirmative action to ensure equal treatment and unequal individuals. This is incorrect. There are two concepts. Equality before law जो है is from British. Always remember B for before and B for British, and it is a negative concept. Okay. And why so? Because means absence of special privileges for any persons, that you do not have a special privilege for anybody, and that is why it's a negative concept. Now another thing is what is equal protection of law, which has is a positive concept, has been taken from America Constitution, and it is a positive concept. It means equals should treat equally, and it allows the state to take affirmative action like reservation. Okay. So you should treat equals as equally, as simple as that. So that is why your statement 2 is incorrect. And statement 3, according to established constitutional jurisprudence, any law enacted by parliament to implement the directive principle of state policies is granted absolute immunity from being challenged on the grounds violating the right to equality under Article 14. Second, according to established constitutional jurisprudence, any law enacted by parliament to implement directive policy principle is grant absolute immunity. So you don't have absolute immunity. Okay. So that is why statement 3 is incorrect, and your right answer here is only one, option A. Okay. Then comes your DPSPs. Consider the following statement regarding the nature of directive principle of state policies and in Indian Constitution. Just a sec. Is it visible? Okay. Okay. They are non-justiciable in nature, meaning they cannot legally enforce by the court if the government fails to implement them. The primary objective is to establish political democracy in the country, whereas fundamental right aim to establish social and economic democracy. Okay, now the first statement here is incorrect. Oh, sorry, first statement here is correct and second statement is incorrect. And why do we say so? First statement is correct. देखो DPSP scan, DPSP is something that uh, as a community India should be starving towards. ठीक है, so we should be moving towards DPSP. So because India के पास initially इतने funds और इतना financial capabilities नहीं थे in such a vast country, तो अगर आप इसको जस्टिसिएबल बना देते फंड डीपीएसपीस को, सो एनीबडी कैन रीच द सुप्रीम कोर्ट फॉर सेइंग कि मुझे जॉब नहीं मिल रही है, मेरे को लैंड नहीं मिल रही है, एंड बिकॉज यू हैव अ लिमिटेड रिसोर्सेज, सो दैट इज व्हाई दिस वाज नॉट मेड अ जस्टिसिएबल थिंग. ठीक है. Now, the statement 2 is incorrect. Why? Because the primary objective of fundamental rights is to have political democracy, whereas the primary objective of DPSP is to establish social and economic democracy. So it's not, it's the other way around. It's written opposite. And that is why you have something called free legal aid and such other things like equal pay wala scene hai, uniform civil code hai, and this is the direction where India should be moving. That is why the correct answer here is A. ठीक है. Then come question number 27. The directive principle of state policy constitute a comprehensive socio-economic program for a modern democratic state. Which one of the following is not a directive principle of state policy? To organize village panchayat and endow them with necessary powers to function as units of self-government. To promote equal justice and to provide free legal aid, to secure for citizen a uniform civil code throughout the territory, to preserve the rich heritage of the country composite culture. So right answer here is D, that is to value and preserve rich heritage. This is the fundamental duty. This is not your DPSP. ठीक है. Then can question number 28. Consider the following statement regarding relationship and legal supremacy between fundamental rights and directive principle of state policies as evolved through Supreme Court judgment. Now, in the Champakaran Dorai Ranjan case, the Supreme Court established the principle that directive principle must conform to and run as subsidiary to fundamental rights. ठीक है, this statement is correct. Then, at present, any law enacted by Parliament to give effect to all directive principle in Part 4 enjoys immunity from being challenged on the grounds of violating Article 14 and Article 19. The statement 3 is in the Minerva Mills case, the Supreme Court ruled that the harmony and balance between fundamental right and directive principle is an essential feature of the basic structure of the Constitution. Statement 3 is also correct, Statement 1 is correct, Statement 2 is incorrect, and we have discussed that already. Why Statement 2 is incorrect? Because it doesn't have, the Supreme Court said that blanket extension nahi ho sakta. It is not complete immunity, as we have discussed earlier also. So only those laws enacted and implement the social directive under Article 39B and C enjoy the immunity, not all the DPSPs. ठीक है. Then the next question is consider the following statement regarding structural and judicial interpretation of directive principle of state policies. To provide a clear framework for governance, the Constitution of India explicitly categorize the DPSPs into three legal ideological sections: socialist, Gandhian, and liberal intellectual. Okay, now this statement is incorrect, and I'll tell you why this statement is incorrect. Because although the division is such, although there are fundamental DPSPs in those categories, we have done that, but कॉन्स्टिट्यूशन के अंदर कोई क्लियर डिस्टिंक्शन नहीं दे रखा है, ठीक है. दैट इज वाई स्टेटमेंट 1 इज इनकरेक्ट. स्टेटमेंट 2 की अगर हम बात करें, डीपीएसपीज आर नॉन जस्टिसिएबल. The Supreme Court has established that court can rely on them to determine whether legislative restriction placed on a citizen fundamental right under Article 19 is constitutionally reasonable. Now this is also correct. ठीक है. Third is the Constitution contains socio-cultural directive addressed to states that are located completely outside Part 4, yet they share the exact same non-justiciable nature as the standard DPSP. Now, statement 3 is correct, and let's see what are those provisions. Claims of SC/ST to services, instructions in the mother language at primary stage, development of Hindi language. Now, these, despite being there out of the part for the Supreme Court, has given them equal and weightage to standard DPSP and are similarly non-justiciable. Okay. Now, this was it from today, and we'll do the remaining questions. So, we are left with question number 30 to question number 50. We'll discuss them either tonight or maybe tomorrow morning. Okay, I'll share the update when we'll be discussing that. So for now, goodbye. And if you have any questions, any doubt, please feel free to reach out to us. Thank you. Have a nice day. Bye bye, guys.